Please be seated. The court is now back in session. The floor is now given to Nuon Chia's defense to respond to some questions as put forward by the trial chamber. You may proceed.
Thank you, Mr. President, Your Honours. Good morning, Council. We shall be brief today, Mr. President. We have no submissions or observations at this point on which specific paragraphs of the closing order to be added to the scope of the trial. So, no specific submissions in respect of paragraph 2 of the memorandum of your trial chamber. In respect of paragraph 3, we reiterate what we have argued yesterday. Yesterday we argued that we hold the position that no witnesses should be heard until the chamber issues a decision as to the scope of the trial. Any witness already scheduled whose evidence could reasonably be expected to touch upon any new issues not previously included within the scope of case 002/01 should, in our view, be delayed for a period sufficient to allow all parties to adjust their preparation. Concretely, Mr. President, that means the questions raised by the trial chamber in numbers 3 and 4 of paragraph 3 should be that no testimony of experts Short and Becker and of witnesses TCW 724, TCW 794, TCW 100 and 110 should be given. So no testimony of those experts and witnesses until the decision has been made by the trial chamber. We do have two small points for clarification. We have read in the memorandum that the trial chamber has indicated that there might be problems with the two experts, Short and Becker, for them to come here to testify. We understand it to be such that they have been rescheduled and so many times that they might be fed up with actually wanting to appear. I don't know if that's the case, but we would like to have some clarification on that point. And further to what the co-prosecutor has said about the timing of Philip Short as an expert, that is in the memorandum scheduled next week, but also the defense team, the defense has anticipated that next week would be a recess and no witnesses were to be, or experts were to be heard. Then I'll go back now, Mr. President, to paragraph 1 of number 3, that is the issue of health of our client. I agree with Mr. Lysak when he said this morning that experts can only determine if our client is currently fit. It's not possible for them to sort of give a schedule on how the fitness of our client is developing and in which way. What I can say is that our client is getting better. We are very happy with that. As you know, I have said earlier that he was approaching death. Well, of course we all are in this life, but the pace has considerably slowed down, we are happy to say. Actually, he hopes to be fully fit as soon as possible. It seems that he is recuperating in the period of recovery that stands for acute bronchitis, which is usually 4 to 6 weeks. And once he's fully recovered, he anticipates to fully participate in this trial. I move on now, Mr. President, to answering the points raised in paragraph 4 of your memorandum. As you know, when he was in hospital, our client has waived 2 or 3 times his right to be present during testimony. This might be the case in respect of S21, if that is indeed going to be your decision. It's not very likely that he's going to waive, if that question arises, substantial S21 witnesses. And I think our view is that we will cross the bridge when we get there. In addition, what I could say is that, and it is also replying a little bit the points raised by the co-prosecutor yesterday, that in August we have come up with a list of 31 potential witnesses in the event that S21 is added to the scope of the trial. We are currently reviewing this list, and it's not unlikely that the number of witnesses on that list will be brought down. But it was simply not possible to come up with a definite answer in this respect, because we haven't been able to speak to our client on this specific point because of the fact that he was brought back to the prison. We only had limited time to speak to him. But we will get back to this issue. But of course, reiterating that in our view, S21 should not be part of an extension of the scope of the trial at all. But if it does, we will come up with a review of the witnesses fairly soon after your decision. I'll move up, Mr. President, to the last point of paragraph 4, and that is the admission into evidence of case 001 transcripts concerning S21. If we will contest the admission of those transcripts, that depends, in our view, of course, on which particular evidence is contained within the transcripts. We are fully aware of your decision, and we will review the particular evidence that is related into those transcripts, and we will object if necessary. Thank you.
President, thank you, Defense Counsel. The floor is now given to Ian Sari's defense.
Good morning, Mr. President. Good morning, Your Honors, and good morning to everyone in and around the courtroom. And again, thank you very much, Your Honors, for giving us this opportunity to answer these questions. So let me begin on paragraph 3 with the first issue. The way I read the question, you're asking whether or what impact what we hear from the doctors will have on the scheduling or the scope of the trial. Our position is, first we have to have the medical reports, you have to have the medical reports, and once you have the medical reports from the doctors, then you will be in a better position to at least know what their current condition is and what is projected down the road and what recommendations they may have, which is why I thought the question coming from Judge Fens was right on point concerning whether we have to have half days or 3 days a week or what have you. So until we hear from the medical doctors, it is our submission, you're not in a position to really fully address that issue, especially when the Supreme Court indicated that that is one of the factors to be determined, a factor which you indeed determined as one of the factors in your severance order. So that's our answer to that one. Regarding the second question to paragraph 3, or it's more of a statement, but it's our position that 2 or 3 weeks is highly ambitious, especially if you're going to have to come up with a plan. And we submit, whether you go with option number 1 or option number 2, you still have to have a plan. I don't want to repeat myself, but you have our submissions on that. And I don't think that you can simply park the issue as to the remainder of the closing order that will not be tried to some other date or a year thereafter, after you render your judgment. So I would say that it's more likely going to take a month. And I am of the opinion, or we are the opinion, that we want a reasoned decision before anything is done. And the simple reason is this. It's easy to issue a decision. It's the reasoning behind the decision or the lack thereof, or supposed lack thereof, that brought us here in the first place. So not to say, well, gee, don't worry about it. We'll accept your reasoning down the road. Well, not so. Especially if the plan that you propose, which you have to propose if you go with 1, and I dare say even number 2, is not accepted, or the reasoning is not accepted. So to say, just give us a decision, then we'll go forward. Your reasoning is still your decision will still be subject to appeal, which may be subject to more delays, and therefore I don't think that is such a good idea. And keep in mind, the defense did not appeal your decision to sever. In fact, we supported it. And if you read very carefully my response to the appeal, I was rather critical in the manner in which the prosecution was interpreting the order and the law that they were relying on. But that's another story. But I want to make sure that everybody knows where we stand. With respect to Short and Becker, let me start with by saying they're journalists that wrote books. They're not experts. You can call them experts all you want, but they're not necessarily experts. They may have something to contribute. We submit whatever it is. It should be based on what they actually know, not what they've read from other academics and have repackaged and put their spin to in their books. But be that as it may, with respect to Elizabeth Becker, it is widely known that she comes to Cambodia often. And so while it may be an inconvenience for her being rescheduled, as far as I am personally aware of, she seems to enjoy coming to Cambodia and comes rather often. She has some attachments to NGOs over here. So I'm certain, given the fact that this is a trial that is being covered around the world, her book is being discussed, which may mean further sales. I'm certain that both Ms. Becker and Mr. Short, if they wish, will probably come. So, and frankly, I don't think that decisions by the trial chamber at this stage, given the magnitude of the issues, because if you look at the Supreme Court chamber, one would think that it was almost midnight at the ECCC with your order to sever, that we should be concerned so much about Becker or Short or any other witnesses scheduling. Right now, we need to get this right. And we would submit that the best approach and the most efficient approach is for your honors to deliberate, come up with this very comprehensive reasoned decision, which is expected from the prosecution as well as from the Supreme Court. And you cannot do both if we're taking evidence, especially important evidence, and at the same time drafting, with all due respect to all the fine legal officers that are assisting the trial chamber. And I do not mean any disrespect by saying it will take more than 2 or 3 weeks. I'm sure they're very bright and they're very talented, but the judges are the ones ultimately that have to be engaged with the support staff in reaching these sorts of decisions, which no doubt the Supreme Court will be looking at rather carefully, especially given the tone of the decision itself that they issued, which, might I say, and it may be a gratuitous remark, it bordered on the personal. With respect to the next question, I believe I just answered it as far as other witnesses. We maintain that we should hear no further witnesses, and one of the reasons was also pointed out by the lawyer from the civil parties. It makes no sense. It makes no sense to call some witnesses now, take some of their evidence, and then call them back later on. There is a logistical, it becomes a logistical nightmare. Plus, might I add that this institution at this point in time is barely able to pay the most important people in this institution, which is the national staff, because without them we can't function, on a timely basis. So have we thought about the costs of bringing witnesses back to give evidence? So I think that's also a logistical issue that needs to be considered. But we maintain, because I don't want to be misunderstood, that somehow I have come in here with a different position, but we maintain that the easiest way not to lose time is to try the entire case, which means that starting after, assuming next week is indeed a recess, which is what I believed it was, but assuming that is the case, the following Monday, we can begin hearing the witnesses that we have planned, while the trial chamber begins to put forward a plan for calling the rest of the witnesses. Hence, no waste of time. In fact, if we do it that way, you don't even have to draft a decision. You don't have to make a choice number 1 or choice number 2. And the prosecution, for a change, I hope, they will not stand up and say, gee, that wasn't one of the options that was given to you by the Supreme Court. Because you have unfettered discretion when it comes to the entire closing order. And you can try it. And we submit that is the only reasonable thing to do. So rather than lose the 1 month, why not begin by hearing the evidence as that we already are scheduled to hear, while making plans to hear the other evidence. And as I've indicated, since the prosecution keeps talking about their burden of proving the case, which I agree, and since we've been reminded by the Supreme Court, at least in their interpretation, and in the manner in which they extrapolate ICTY jurisprudence dealing with dismissing counts in order to justify and to interpret ECCC rules that deal with severance, and that we are in this adversarial setting, the prosecution should put forward their list of witnesses, their list of documents for the entire case. Now that there is this impending need to move with all deliberate speed, I am sure that this might have focused the mind in actually determining what are the real witnesses that they need to call, the actual evidence they need to introduce in order to prove their entire case. Because up until the time the trial chamber decided to sever, the mind was not focused, as far as we're concerned, from the prosecution, because they assumed that they could try their entire case, throwing caution to the wind, disregarding the age of the accused, thinking this was going to be a walk in the park for the next 2 or 3 years, only to come to find out that there was a wake-up call by the trial chamber that one of the factors is that we might need to try this case in stages because of the age. So I would suggest that we try the entire case. We start a week from Monday. There's no need for you to come up with any plans. There's no need to jettison any of the civil parties who will be abandoned after all they went through to register as civil parties, after all what the pretrial chamber did, to have to get them reinstated after they were thrown out, or some of them were, by the OCIJ. So that's the solution. Paragraph number 4. And, we're told that we're going to try this case with a limited amount of witnesses, a limited amount of time, and I sort of hesitate to answer this particular question in the way it's framed, but you see, the trial chamber seems to be inviting us for our opinion. And I'm reminded of Mark Twain, the great American author, novelist, who once commented about statistics and the use of statistics. Because when we're talking about how many witnesses, how many days, how much time, we're talking about statistics. And this was his observation about statistics. There are statistics, there are damn statistics, and then there are lies. Now, what did he mean by that? What he meant was, when we're dealing with numbers as statistics, they're malleable. They're easy to manipulate. They're easy to misinterpret. And their statistics of 11 days may be 11 actual weeks when it comes to the actual edition that they're asking. So we hesitate to simply rely on statistics, but we certainly think that the trial chamber must have considered the 11-day projection that the prosecution had already informed the trial chamber when the prosecution at the very end had asked for additional expansion of the scope. This was not a figure that we just heard for the first time or that you heard. Now, frankly, I cannot believe that the trial chamber did not see that figure, did not factor that figure into its own accounting, and perhaps with the knowledge of what is at stake, probably scratched their heads, the judges, said, something doesn't sound right. 11 days sounds a wee bit too short and a wee bit too unrealistic. And so that's why I'm reminded of Mark Twain's use of his characterization of statistics. I think we are on perilous ground if we're going to rely on this 11-day projection. Everything will be happy and solved in 11 days, especially if we bring in all sorts of stuff coming in from other cases or other statements or other transcripts, which we are on record, we will oppose. So, to answer the questions, on the projections, we've already indicated. As far as, how many days each of these witnesses, these are what I would call known unknowns. That's how I would put it. I would borrow a phrase from Rumsfeld, not that I want to, but the former Secretary of Defense from the United States said that there are known unknowns and there are unknown unknowns, and that we're in one of those known unknowns. I know that I don't know. And neither do you, Your Honors. And so we have to see how it goes. And that's why I think it is much more prudent to just proceed with the entire trial. Question number 2. Could the defense teams indicate whether their client's willingness to waive their right to be present? Well, I think we have been loud, we have been clear, we have been consistent. And let me repeat myself for our position thus far. We have filed written submissions with our client's written notice to the trial chamber that he does not wish to waive at any point in time his presence. Now, there may be the exception, but I can informed the trial chamber that at this point in time, it is his intention to not waive his right to be present. He's entitled to that as much as somebody who is robust and young and able and willing to sit through the trial. And if this institution is going to abide by the so-called international principles and standards, which are embedded in the Cambodian Constitution and are attached to the jurisprudence of the ECCC and the agreement and what have you, then this wish has to be this exercise of his right has to be granted to him and cannot be taken away. So, I believe that answers that question in a rather unequivocal fashion. Then we get to question number 3. Whether the defense teams should, whether or not they would seek to contest the admission into evidence from case 001, transcripts concerning S21. Well, let me just be very laconic on that. Yes, we will. We will be contesting that. In fact, we will be contesting everything that the prosecution may try to bring in, either from 001, any transcripts of testimony. I mentioned that. It wasn't by coincidence, and it certainly wasn't by serendipity that I stood up and I asked concretely whether the prosecution's projections that we heard on Monday, where they represented to you that this is just a mere 11 more days, whether they also factored in the testimony. And there was a question from the bench. And if you look at the answer, it was never really answered. And so I suspect that they will try to admit, and the trial chamber may try to admit, but we will object. So, no quarter sought, none given. We're going to try this case. The prosecution has a burden. They know what their job is. They're prepared. They're organized. And so, but they're going to have to follow the proceedings and the procedure that are consistent with the international principles. And we will be objecting to anything coming in where our client's right of confrontation is compromised. Period. I trust my comments sufficiently answered the trial chamber's questions. Of course, I'm available to answer any questions the bench may have. And certainly, we are looking forward, I should say, to replying to the prosecution's reply, sur rebuttal or rejoinder, as it's said, should the trial chamber grant this wish, which seems to have been made by at least the civil parties, and perhaps the prosecution has already anticipated to be asking Your Honors. Thank you very much.
Thank you, Counsel. The floor is now given to Keels and Pond's defense.
Thank you, Mr. President. I think I can be brief here. I don't intend to go over ground that's already been covered and on which we agree with the other defence teams. On the question of the importance of the health of the accused, I can only say that, of course, we agree on this point. My colleagues from the other defence teams say that the more you judge from the closing order, the quicker you will proceed. I agree with that in principle, and that is why yesterday I said that's probably what we should have done from the start. However, I'm a little more pragmatic as well, and I am bearing in mind the fact that the trial did start a year and a half ago. I am
mindful of these health issues and the fact that my client is in good health and that he is entitled to an expeditious trial. I also consider the fact that the assessment I have made of your Chamber's opinion up to now, not only through the series of decisions that you handed down on the subject of severance, but also the impression I at least seem to be having from the questions that you prepared for these hearings in your two memoranda that we are trying to answer for the last 2 days. And it seems to me that your Chamber might be tempted to continue to cogitate the form of things, options 1 or option 2, but as far as we, the Kyosampan defense team, are concerned, it amounts to the same thing. It signifies a succession of trials, and that, according to the Supreme Court, means that you have to say how you plan to do it and how you intend to solve all of the legal and technical questions that arise when severance takes place and there is a series of trials for Mr. Kyosampan. Now, with respect to the witnesses that you might decide to summon prior to handing down a decision, well, our position on that is the same as for the other defence teams. In this, I echo my learned colleagues. I would have thought that there's quite enough wind in the sails already. And yesterday, with your call for prior drafting of a part of the final memoranda on applicable law, and that each time a difficulty is encountered, then that will ricochet and have consequences on the timetable that we will try and solve step by step. Well, I believe that the wise course of action is to follow the decision that you took for the two witnesses that were planned for this week, which is not to hear witnesses until you have given a complete, reasoned and executive decision on what you intend to do in the future. I don't think it's reasonable at an early stage to give us a decision that is not reasoned, because that is precisely what the Supreme Court criticized. If you do that, then you may end up doing things, acting in a manner that is contrary to what you have been instructed by the Supreme Court, as to arguments whereby Mr. Chandler was heard on the entire dossier. Well, I challenge that. I can remember perfectly well when he came to this courtroom, Judge Cartwright began his hearing by telling him what the scope of the trial was. Now, I've checked this. She told him what the scope was of the first trial, so that that particular expert could focus his remarks on the definitions given in your severance decision. So I think that argument is ill-founded, and to say as well that we've already been told that experts Becker and Short should be heard on the whole of the closing order. Well, I'm not sure about that. Perhaps I might quote a memorandum which you gave us on the 8th of January 2013, in which you told all of the parties in E236/4 that the hearings for Philip Short and Elizabeth Becker that were planned for a week would only in fact last 4 days, and that you encouraged the parties to limit their questions. 2 points solely connected with the first trial in 002. So all of these difficulties that come up as we go along and which change the scope of the trial are going to be continuing to cause us all harm and prejudice, and you have to lay a healthy foundation for the continuation of the trial rather than trying to plan as things come up and deal with the contestations as they are expressed, because that's not an efficient way to do things. And my comments apply to other possible witnesses. I'm stating a general position here. We believe that we have to wait for your decision in its entirety on how the future will be organized before we go on to hear other witnesses. As for question 4, Roman 1, I think I've probably said enough already yesterday about planning for the future timetable. You know my views on this, and I echo the views of the other defence teams. We don't know exactly how such planning is done. Does it take account of our different statements? This is a kind of internal housekeeping, but it's not sufficiently clear to all of the parties. In October 2012, as you reminded us just now, Mr. President, you opposed the prosecution's estimate of 33 days. Let me move on to the next question. Are we prepared to waive our right to be present in the trial? Answer is no, quite obviously. And finally, would we contest the acceptance of the transcripts of trial number 1 if they were requested by the prosecution to justify their work? Then the response is positive. Like the other teams, we will review the situation and, where necessary, raise objections. Thank you.
The President. Thank you. Now I hand over to the co-prosecutors and the lead co-lawyer for the civil party to respond to the various points raised by the 3 defense teams. You may proceed.
Thank you, Mr. President. I will be fairly brief. First, in regards to the issues raised regarding the health of the accused, let me say that I appreciate very much Mr. Kope's candor regarding the health of his client. I think that is in line. I had assumed after thinking about yesterday that if the defense were proposing to this chamber that adhere the entire charges of case 002, that it was likely that their view that was that their clients were at least currently fit and likely to be fit for the immediate future in any event. And we certainly appreciate his candor on that issue. And not just on that, let me add, it's refreshing to hear respectful and clear submissions coming from his chair in the courtroom. While we may disagree on the substance of them, we do appreciate the change that is taking place. And I would add, I appreciate also his indication that they would review the 31 witnesses that they had proposed. And I would add, I hope the same wisdom that led him to change his position on severance yesterday would also apply in his review of the witnesses that have been proposed. We do disagree with all the defense teams on this issue of whether the chamber should proceed with witnesses pending its decision, though it was a little unclear to me what the Ing Sari position was, as he indicated that the court could start hearing witnesses a week from Monday. The first two defense teams did not really respond to the issue we raised regarding Becker and Short, which is that if the scope of examination has been authorized for them for all case 002 issues, there really is no reason not to proceed at this time. And Mr. Verkin did respond to that issue. I simply disagree with him. The records are very clear that the court authorized examination on the full scope, and that is also the case with the other witnesses. The key word in the document he cited is that the court recognizes that parties are authorized to ask questions on the scope where they are relevant to the witness, to what the witness knows, but encouraged, obviously, to focus on the most significant issues. We have obviously been preparing for both of these witnesses for a long time, and I can simply tell you that there is no reason not to proceed with them. They are both witnesses that fall into this category I talked about yesterday of foundation witnesses, witnesses whose testimony provides the general foundation on which the court can consider all crimes. And nobody is proposing that additional time is needed. I think it is extremely unlikely that anything would arise which would result in the need to recall these witnesses, and we would encourage the court to proceed with them. And the last point that I wish to address is Mr. Carnivus taking issue with our time proposal. On the one hand, he has stated over and over again the importance of having a specific plan and schedule for going forward. But when we give a specific proposal on how to go forward, he quotes Mark Twain. And I did not hear any counter-proposal from him. I did not hear him say, we actually need more time with any of these particular witnesses. I did not hear that from any of the party. But this is within your power and authority. We've made a proposal of the time that we believe is necessary for those witnesses. We believe it's consistent with the time that has been required with witnesses to date. I refer you to the proposal we made back in August, a specific plan that included time for all witnesses remaining to be heard in the case, which is E218/2.2. If you look at those time estimates, you will see that our estimates have worn out to be quite accurate. But more importantly, you set the limits. You can decide that 11 days is too much, that we really only need 9 days, or you could decide that we need a few more days than 11. That is your power to set the time and the schedule. And I think that responds to everything that the defense said. So unless the chamber has any more questions, I will cede the floor to the civil parties.
The President. Thank you. Now I hand over the floor to the lead co-lawyers for the civil parties to respond to the answer as well as the points raised by the three defense teams. You may proceed.
Your Honours, just very quickly, in response to Counsel Michael Carnaves's submissions, well, firstly, this is not a hearing about the characterisation of experts or factual witnesses, and I don't think it's very useful to the Chamber for Counsel to be speculating about the willingness or not of expert witnesses to attend to give evidence. Yesterday, Counsel Carnaves also suggested that Your Honours in the trial chamber have absolute discretion in respect of decisions on severance, and in fact, he reiterated just now that you have unfettered discretion in relation to the whole of the closing order. But Counsel also now says that he might not accept a decision of the trial chamber if the plan or outline or the reasons don't suit his client, and that nothing can proceed until a full and reasoned decision is given. We are now in a position of compromise. Efficiency and trial management needs to be balanced with the rights of all parties, including the rights of the civil parties to have a final determination in case 2. Of course, as my learned colleague, the international lead civil party lawyer, submitted yesterday, or the day before rather, in an ideal world, yes, all of case 2 would be tried before Your Honours, and the victims would have a voice and have their stories heard and be given the opportunity to raise in a public forum the atrocities which they have experienced. But we are in a position of compromise now, all things considered, and all of these things need to be balanced. In relation to Counsel for Kyo Sam-Fong's submissions regarding the trial chamber's memo of the 8th of January, E236/4, I reiterate and concur with the submissions made by the learned prosecutors, emphasising that the trial chamber encouraged expert examination to be focused on matters within the first trial. Encouraged. But of course, there are numerous rulings, oral and written, that experts can speak on matters within the scope of the entire of case 2. Finally, it is extremely difficult for the civil parties to see the logic in counsel submissions that, and I'm speaking about Counsel Michael Carnaves, that it would provide the most expeditiousness to try the whole of case 2, when in the same submissions, counsel says, and I quote, "We will contest everything. We will object." And this was just in relation to the admission of documents in case 1 relating to S21. Those are the submissions I have in rebuttal.
Just a supplementary comment on the subject of transcripts. Your chamber has already issued a decision on the transcripts, at least that is based on my interpretation of E96/7. The chamber had provided reasoning for its decision and made it very explicit as to how the transcripts could be used in the context of case 002. The defense has already stated very clearly that it will challenge the admission of such transcripts from case 001. Now, if the defense does indeed intend to launch objections, which is entirely free to do, those objections must go above and beyond the issues that you have already previously ruled upon. I do not believe, at least based on my knowledge of the legal issues, they cannot lodge objections on issues that have already been ruled upon, for which there is a determination. Their objections simply cannot address those matters afresh. Thank you.
The President. It has to begin in order, starting from the defense team for Mr. Nguyen Chia, replying to both the co-prosecutors and the lead co-lawyers for the civil parties.
Thank you, Mr. President. We have nothing to reply on the substance, except to say that we do appreciate the words of the co-prosecutors. Thank you.
The President. Counsel Kanavas, you may proceed.
Thank you, Mr. President. I'll speak slowly. Perhaps some is being lost even in the English language to the English speakers. First, let me be clear so the prosecution knows exactly where we stand. When I indicated that we can begin immediately, that is a week from this Monday, I believe it would be March 4, and we would lose no time, we would not have to reschedule those who are already scheduled, is on the basis that we try the entire case, and that you would not have to waste your time writing a decision and trying to figure out a plan. So I hope that is crystal clear. Second of all, to my colleagues of the civil parties, which seem to have misunderstood when I said unfettered discretion. You have unfettered discretion to try the entire case. The Supreme Court has not said you cannot try 002. They have no authority to do that. They have not stated that. And the civil parties ought to know that. So you have that discretion. Now, should you choose not to try the entire 002 case, then you will have to go to option 1 or option 2. And while in option 2, the Supreme Court has not stated that you need to come up with a plan. We submit you still will have to come up with a plan, because in this system, unlike the Anglo-Saxon system, you cannot simply dismiss counts. And to suggest that they could be out there suspended indefinitely while someone enjoys the right to an expeditious trial, it is nonsense. I hope I'm clear on that point. As far as we will object everything, well, gee, what do defense lawyers do? They come and they defend their clients. Perhaps I was misunderstood. Perhaps I didn't know what my function was as a defense lawyer. Yes, I am here to be reasonable, to be cooperative, to be of assistance, but above all, I am here as my client's champion. I'm here to make sure that he gets a fair trial, that his rights are protected. And I'm entitled to use the rules and the procedures. And to suggest that I should just come into court with bended knee, with cup in hand, seeking some sort of justice by admitting transcripts from a previous trial where the lawyer effectively took his client in and pled him guilty and did not challenge much of the evidence, or if he did challenge evidence, it may have suited his case, his strategy, his theory, and then to expect the Ng Sari defense team to come in and say, yes, will accept that testimony without challenge, that would be, in my humble submission, ineffective assistance of counsel. I should lose my license should I come and defend a client this way, and I dare say, I hope other defense lawyers do not do that. Now, how can I say we will object to everything and ask for an expeditious trial? What I am suggesting, Your Honors, is we're losing a lot of time and we've lost a lot of ground figuring out where the contours are. Yes, our clients are of an advanced age, but we can proceed a week from Monday with hearing the evidence. That's what expeditiousness means. And let me, since we're on that word, how do we justify, and how does the Supreme Court chamber justify parking the rest of the closing order and at the same time afford expeditiousness? It's schizophrenic. So when I speak of expeditiousness, I'm talking about the entire case. And yesterday we heard a rather eloquent argument from the Q Sampon team where they were talking about
the President. Please, Counsel, be reminded to slow down for the proper record, and please be specific to the point. You are supposed to only reply to the specific matters that were raised by the co-prosecutor and the lead co-lawyer for the civil parties, because you were given time yesterday to address matters as well. So please respond or reply to only the responses by the two parties. So you were supposed to only respond to the last responses raised by co-prosecutor and lead co-lawyer. So please confine yourself to this area. If you try to respond, I believe that it will be lengthy, and it may be even longer than the hearing yesterday. And please try to speak rather slowly for the proper record.
Thank you, Mr. President. I was responding specifically to the lawyer from the civil parties who stood up and was flummoxed about how, on the one hand, I could say I'm objecting to everything, while at the same time arguing for an expeditious trial. So I just answered the role of a defense lawyer. Perhaps my colleague wasn't aware what we do on this side. And so perhaps that answers the question. As far as expeditiousness, how can I argue both? As I was indicating, yesterday we heard from our colleague from the Q Sampon team indicate why Mr. Q Sampon is prejudiced because he's not getting an expeditious trial. So my point was, if we want to be expeditious, let's take the path of least resistance. There are ways of looking at the closing order, the entire closing order, and if the prosecution had a focused approach, I'm sure they would find a way to try the entire case within an expeditious time frame. And as I indicated earlier, you have unfettered discretion to say, since the Supreme Court, in their infinite wisdom, at this stage of the proceedings, in light of what is going on, in light of all the other factors, annulled your severance order, we are back to square one. There is no severance order. Now, if the prosecution then wishes to make another submission seeking severance, well, they can have at it. But you're within your rights. You are seized with this trial. So you can begin to try the entire case. And we say, do so. And that will be expeditious. And as far as raising other objections, when circumstances change, even where matters may have been ruled upon, if the circumstances require a legal objection or a procedural objection, not one that is frivolous, not one that is repetitive. But if the circumstances so require, I can assure the trial chamber that the Inksri defense team will not hesitate to file submissions. I think the record is rather clear that we file submissions whenever we think it is necessary to have something resolved or to at least make a proper judicial record. And we take to heart that issues that have already been ruled upon that need not be readdressed, we will not readdress them. We have been rather modest in our approach of challenging matters that we think need to be challenged, and where issues have been resolved and where we are of the opinion that they have been resolved satisfactorily to our beliefs of what the law and procedure is, we choose to accept them and move on, such as, to give just one minor example, your order to sever the case. We accepted it, we supported it. And then when the prosecution moved for reconsideration, we parted ways with the prosecution because of the manner in which they wished for you to sever the case. And I believe I've answered everything that was said by both parties on the other side. Thank you.
The President. International Counsel for Mr. Kyu Sampon, you may proceed.
Thank you, Mr. President. Just two clarifications. Firstly, on the subject of the hearings of the testimony of Elizabeth Becker and Philip Short, it is now very clear that the co-prosecutors and the civil parties are stating that the memorandum that I had read from, dating from January 2013, would only serve as impetus for the teams to focus on the subject of the trial. But they seem to have forgotten that in addition to fueling the parties to concentrate on this second trial, through that very memorandum, your trial chamber had reduced its sitting weeks from 4 to 3 days a week. And that we are being told to focus on the trial as it is currently being defined, and yet the sitting days would be diminished. Well, what is the state of affairs? Very obviously, you are preparing yourselves to question the witnesses on the scope of the trial as was defined in January. I think we need to stop focusing on semantics and playing with words. Let us be very straightforward. Let us stand by our principles, reach a very clear decision, and make progress. My second clarification is as follows. My learned friend from the civil parties is feigning and claiming that your trial chamber has already reached a decision based on its last memorandum regarding the admission of transcripts of evidence from Duke's trial. Indeed, this chamber has established the criteria for admissibility of written statements in lieu of oral testimony. However, our duty, from the moment that the co-prosecutors propose the admission of documents, is to verify whether or not those criteria are satisfied, and that we are entitled to raise objections. And this is exactly what the defense team from Mr. Kyu Sampon is talking about, and will stand by.
The President, on behalf of the judges of the bench and in my capacity as the President of the Chamber, I would like to thank all the parties for expressing their views in relation to the question raised by the Chamber following the hearing of the views. The Chamber will render a reasoned decision in due course with regard to the scope of case 002 to be heard in the first stage based on the consideration of the factors and points raised in the decision of the Supreme Court Chamber on co-prosecutor's immediate appeal of the trial chamber's decision concerning the scope of case 002/01, document E163/5/1/13, by incorporating all the submissions and views of the parties concerned. And as for the scheduling of the hearing of the expert witnesses as well as evidentiary documents, 2 expert witnesses and 4 witnesses, the Chamber have asked the parties for their views on paragraph 3 of the memorandum of the trial chamber dated the 19th of February 2013. The Chamber will specify the date of the hearing of this issue tomorrow. The hearing of the testimony of the witnesses as well as the experts following this hearing and before the Chamber renders the reasoned decision on the scope of the hearing in the initial stage. The Chamber cannot make the decision now because the Chamber will have to take every view of the parties into consideration, and the Chamber will render the decision in due course to all parties concerning the scheduling order before the Chamber render the new decision following this hearing. And the court is now adjourned, and the Chamber will notify the parties for the next scheduling order in due course in relation to the hearing on evidence and witnesses. Security guards are now instructed to bring the co-accused back to the detention facility of the ACCC. And the Chamber will issue an order again to bring them back to this courtroom.